And everyone, welcome. Thank you for coming. We really appreciate it. We have here today, we have Manager Von Rett. It's on.
It doesn't seem.
Take a moment. Okay. Esteemed delegates and observers to Working Group 5 and many friends of UNCITRAL, International Insolvency Institute at Sigmund Freud University. I specifically want to thank at the outset Alexander Klauser. He did the laboring work organizing this, and we really, really appreciate it. It's wonderful so far. I also want to thank my dear friend Evan Zucker, who also had a hand in planning and helping out with this event. I'm Adam Swick. I'm the chair of the Triple I's delegation to Working Group 5. On behalf of our organization, in conjunction with UNCITRAL and Sigmund Freud University of Law, I'm very happy to welcome you to this program. I think it will be very exciting. Mediation is an effective tool in enterprise group insolvencies. I also have to point out that Triple I very much values its long-standing partnership with UNCITRAL and many goals accomplished, those still to be accomplished by Working Group 5. Triple I and its members participate as members of many NGOs and also act as official state delegates. They have participated eagerly in the Working Group for many years and are thrilled to continue contributing to important roles and activities. Now, there's been a growing use of mediation in the context of insolvency proceedings. Mediation is used to support the facilitation of restructuring plan among debtors and creditors. It's also used to assist resolution of contested issues with the collective insolvency proceeding. There are many texts which lay the groundwork for and considering putting the model on. I think Justice Ramesh, president of Triple I, has said it best. Mediation undoubtedly promotes compromise, saves time, minimizes costs, and yields more meaningful consensual outcomes. Court-to-court communication and cooperation will enhance the effectiveness of insolvency mediation in a cross-border setting. The goal of today's panel is to encourage mediation and other dispute resolution mechanisms to enable cross-border insolvency issues to be resolved efficiently and effectively. Today's panel includes an esteemed group of insolvency participants from most civil and common law jurisdictions and are sure to provide informative and interesting perspectives, and I'm highly anticipated to be very entertaining as well. It is my pleasure now to welcome Manager Von Rett, Secretary of UNCITRAL, to make some introductory remarks.
Thank you very much, and good evening to all. Working Group 5 never ceases to amaze. You spent a whole day deliberating on difficult topics and working hard, and in the evening you're still enthusiastic about discussing your topic and including other topics that come up in the context of your work. So a few words of introduction, essentially to thank you all for being here, to thank the Triple I and the Sigmund Freud University for welcoming us to these wonderful premises. It's the first time that it's not the first time I'm crossing the Danube, but it's the first time I'm coming to this part of town, and I'm quite amazed at the beautiful premises you have here. So thank you very much for having us. Ladies and gentlemen, it's a great pleasure on behalf of the United Nations Commission on International Trade Law to join the Triple I and the Sigmund Freud University in opening today's event on enterprise group insolvency and mediation, marking the 5th anniversary this year of the model law on enterprise group insolvency, also known as the MLEGI. UNCITRAL welcomes, and I'm particularly keen on putting emphasis on this interdisciplinary theme, because international trade is not made of silos that are living next to each other, but rather in ensuring that end-to-end international trade is dealt with and covered in a holistic and coherent manner. So we're very grateful for this opportunity to discuss an interdisciplinary team that touches upon two important areas of work by UNCITRAL, namely insolvency and mediation. In fact, the most recent work by UNCITRAL on commercial mediation proceeded in parallel with its work on the UNCITRAL model law on recognition and enforcement of insolvency-related judgments and the UNCITRAL model law on enterprise group insolvency. So that is for, I would say, you guys, the insolvency experts. But for the mediation experts, we have indeed been quite productive in the last years, since basically 2018, when the Singapore Convention on Mediation was adopted. And since it has really given a second use, a second impetus to mediation as an equally important and valuable tool for settling disputes arising out of commercial relations. UNCITRAL acknowledged the interaction of insolvency and mediation in several instances, including when preparing the text on simplified insolvency regime for micro and small enterprises, which found its way as a part 5 of the UNCITRAL legislative guide on insolvency law, and the UNCITRAL model law on international commercial mediation and settlement agreements resulting from mediation, which is the model law part, which follows almost clause by clause the Singapore Convention, but which was negotiated in parallel to accommodate those countries that would not be able to accede to an international convention. This is not surprising, since mediation has proven to be a very valuable dispute resolution tool in complex multi-party settings, such as insolvencies, of which enterprise group insolvencies are most complex. This is because enterprise group insolvencies involve more than one insolvency estates and insolvency representatives. They also involve multiple distinct groups of creditors and other parties in interest and their representative bodies. Whether in the domestic or in the cross-border settings, enterprise group insolvencies necessitate cooperation and coordination. Acknowledging that, the model law on enterprise group insolvency envisages the appointment of a group representative and the need to negotiate and implement a group insolvency solution in a planning procedure. Such a solution, that's the effects of the Prosecco. I should have said no. Such a solution may concern not only insolvent, but also solvent enterprise group members, complicating matters further. In such a multi-stakeholder context settings, disputes may inevitably arise. They may arise between enterprise group members, between creditors and insolvency representatives, and among creditors. They may arise in the planning proceedings in the negotiation of a group insolvency solution, for example, between the group representative and the insolvency representatives. They may also arise in the negotiation and implementation of the other cooperation and coordination frameworks, such as cross-border insolvency agreements. The value of mediation in all those settings is derived from the very features of mediation. Mediation is an amicable, voluntary dispute settlement mechanism that focuses on building trust and finding solutions. So it's not about saying who's right and who's wrong, but working collaboratively towards a solution to the dispute. And even if it fails, it helps parties to learn and understand positions, interests of each other, and bridge differences, and possibly facilitate the resolution of disputes in adjacent or subsequently commenced formal adjudication. It is worth noting that in comparison with UNCITRAL earlier insolvency texts, including the 1997 model on cross-border insolvency, UNCITRAL later text, including the model law on enterprise group insolvency, explicitly refer to mediation. So you see already building these bridges and moving out of the silo. This is the evidence of an increased popularity of mediation in recent years. However, compelling mediation in court proceedings remains an unsettled issue. Article 10H of the MLEGI takes that approach. It envisages that a court can compel mediation in enterprise group insolvencies in domestic and cross-border contexts. In the light of cross-border insolvency and enterprise group insolvency case law that led to the preparation of the model law on enterprise group insolvency, UNCITRAL considered that approach justified as a means of ensuring cooperation to the maximal extent possible between and among courts in enterprise group insolvency. What merits more analysis, for which I do not have time now, is that the provision is limited to one type of many disputes that may arise in enterprise group insolvency, namely disputes between enterprise group members concerning claims. As we know, the work of UNCITRAL does not stop with its legislative activities. The UNCITRAL Secretariat actively promotes the adoption and the use of UNCITRAL text, and we do that with many stakeholders, and tonight's event here is but the proof of this constant endeavor for more promotion and awareness building activities. And we do that by various means, including by raising awareness and understanding of those texts and building capacity of judges and other practitioners with their use. Recently, we launched at the UNCITRAL website UNCITRAL online courses addressed to students, practitioners, and others wishing to learn more about UNCITRAL and its work. So it's what you always wanted to know about UNCITRAL, never dared to ask. You can find now on the website. We are pleased to announce that the online module on UNCITRAL insolvency text, including the MLEGI, was a recent addition to the courses that were launched earlier, including on the UNCITRAL mediation framework that has attracted thousands of participants until now. All UNCITRAL online courses are currently available in English, and that's very bad, and I regret it very much, but we're doing what we can with the means that we have. And we have some of them already available in Chinese and in Russian. France permitting, we hope to have all the courses in 6 languages of the United Nations one day. But it is feasible to expect that the insolvency module will be available in Chinese as early as next year. Courses in preparation will cover several other UNCITRAL texts, including in the areas of law relevant to insolvency, such as secured transactions. That's one of the forthcoming modules. Please allow me to conclude by sincerely thanking our co-organizers, the III, thank you very much, and the Sigmund Freud University for continuing to support the adoption and the use of UNCITRAL text, including the MLEGI, thereby contributing to harmonization and modernization of this area of the law. We're looking forward to the discussions on this very interesting topic. Where else, if not in the city of Sigmund Freud and the university with its name, may we learn about possible deeper reasons for the use of mediation and its value in enterprise group insolvency. Thank you very much for your attention.
Yeah, ladies and gentlemen, this is the last one who is speaking. Welcome remarks to you before we have our most interesting panel. But let me, in the name of Sigmund Freud University, warmly welcome you all here at our university. We are particularly honored to have you here today, and I'm very thankful, especially to Samira Mosaeva and to Alexander Klauser, who approached us with the idea of having this event at the Sigmund Freud University. What we here as the Sigmund Freud University can offer to mediation in insolvency, I have to say, is very little. We are currently running a school of law, a school of medicine, a school of psychology, and a school of psychotherapy. That sounds quite promising for the topic, but as I was informed, or I informed myself, no scholar of our school investigated the question of mediation as an effective tool in international insolvency so far. This means we, as Sigmund Freud scholars at the university, have to learn and to listen to you today. And our contribution, however, might start, as it is common for Vienna, for our university, with the question, what would Sigmund Freud have said about insolvency? Let me mention now just 3 ideas. First, Freud might focus on the conscious of failure, inadequacy, or loss of control, which could manifest as behaviors leading to an inability to deal with economic stress. This dimension could be a subject area for research and taken into account by mediators. Second, as you all probably know, Freud worked on defense mechanisms, not in a legal sense, of course. But the defense mechanisms he worked on have been denial, repression, and rationalization to cope with emotional turmoil. The awareness of these defense mechanisms might enhance the ability to cooperate in insolvency situations or not, as usual research would show. And third, Freud published significant thoughts on the relationship between law, society, and the individual. And I wonder whether his writing, for instance, on civilization and its discontents, published in 1930, could provide some interesting insights for lawyers reflecting on the use of mediation in international insolvency. To summarize and to conclude my welcome remarks, you bring interesting research question to this interdisciplinary institution. We thank you for that, and we ask you from now on, there will be always a gathering at the Sigmund Freud University before Christmas to progressively develop the international law and to have the force of Sigmund Freud with us in doing that. Thank you very much.
So, thank you very much. Good evening, everyone. My name is Annika. I'm a professor of sustainable transformation at the University of Applied Sciences in Emden, Leer. I'm also a member of the German Association for Mediation and Restructuring and Insolvency, trying to push some things forward. We're not here yet. And I'm very happy and delighted to be sharing this panel. And therefore, I do invite my fellow panelists, Scott Atkins, Leif, Franz, Mohr, and Fruhstorfer to the board.
Whatever you want me to be.
Whatever is done for you.
How about a touch of that, Scott?
Before we start, I would like to introduce shortly the panelists so you know who's going to be sitting on the panel. On my far right, I have so can you hear me better?
Much better, yes.
Johan is saying yes. So welcome again, and I'm going to give you a short introduction to who's going to be sitting on the panel tonight. So on my right is Leif. He's a former bankruptcy judge in the Western District in Texas. And since his retirement, he's been working as a strategic consultant as well as a mediator in complex restructuring and insolvency. Then I have Scott Atkins, which I'm sure does not need much introduction, nevertheless, as an Australian chair and the global co-count for financial restructuring and insolvency for Fulbright in Australia. And he's also been very engaged in diverse capacity and framework building in emerging markets. On my far left, I'm going to come to you in a second, on my far left is Franz Mohr. Franz is a professor here at Sigmund Freud University and also the University in Graz. Before that, he's been a judge also at the bankruptcy court and has been working at the Ministry of Justice on diverse insolvency, all of these, that's what I said, insolvency reforms. As a legislator. It's been working, yeah. Ministry of Justice, yeah. Yes. And then we have Susanne. She's also had her own firm and has been advising clients in diverse matters for the last 30 years in restructuring, insolvency, working as an insolvency administrator, as well as a representative for credit committees. So coming to in mediation, and I'm just going to look on my right side now. What kind of frameworks does your jurisdictions have and for mediation? And if so, are those effective?
So let's start with Scott.
Okay. Well, thank you, and thank you very much for the warm welcome here tonight. And it does seem quite appropriate to be at a university bearing the name of Sigmund Freud, because I think what you'll hear a lot from us, at least from the rehearsal that some of us might have had earlier today, or the discussion, is that so much of mediation is really about changing the behaviour of parties and changing the way that they engage, and maybe having a circuit breaker in the dynamic that otherwise might be underway in complex situations. So I've done my best. I'm taking a global perspective, Annika, and I'll try and bring it a little bit local. But in any event, I've done my best to have a look at what are the frameworks, formal and informal, that inform mediation. And of course, we have to start with the model law. And as you heard in the introduction, the original model law, or the model law, as we all know and love it, does not use in any explicit sense mediation. But what it does, of course, in some of the articles 25 to 27 in particular, and we always need to look for flexibility and creativity, is urge cooperation and coordination. And I think that courts and practitioners familiar with the operation of the model law will easily find ways to manoeuvre and to navigate within those particular articles and those principles to ground mediation in circumstances where it's appropriate or necessary. But let's track right forward, and you also heard this as well, the model law on group enterprise insolvency, a far more contemporary instrument, and expressly and quite explicitly and deliberately builds in mediation as a concept that's urged upon parties to consider in group enterprise insolvencies. And I guess the reason why that's so apparent and why it's emerged in that instrument is that in the complex situation of groups, if nothing else, facilitation in the resolution of conflicting issues and claims within a group is vital. And so mediation, of course, is a tool that should be readily deployed. And you've heard reference already to Article 10H, but I'll also mention Article 15, which, like the model law that I've already mentioned, urges cooperation and coordination upon the parties to the maximum extent possible. So they're two instruments that I think most people in the room would be familiar with in varying degrees. But then, of course, outside of that, there are atmospheric considerations as well. I call them atmospheric. They're much more than that. They're not just pieces of link floating through the atmosphere. But we've had encouragement of mediation by courts, and you heard in Adam's opening remarks, he in fact quoted from a judgment of Justice Ramesh in Singapore, and that is a jurisdiction, and Justice Ramesh, as president of the III, has been a strong advocate for mediation, as I certainly was also when I was president of Insolvencies International. Let's be clear, healthy competition. And of course, this urging from courts, and you'll hear much more about this from our judicial member here tonight, is ever present, and as it should continue. And then finally, I just want to mention another array, because I need to hand the microphone on, but there are significant instruments and frameworks and guiding principles developed by the III and by Insolvencies International. And in fact, I think for many practitioners, they're good foundational places to find guidance. The World Bank principles on creditor and debtor frameworks are vital, and recommendation B4 specifically urges mediation to be considered and built into laws when countries are considering their legal frameworks, and I'll mention that. And I would like to come back, but I'll come back in greater detail later to talk about the Singapore Convention. You've already heard one reference to it tonight. But the Singapore Convention, if we track forward and then look back, if we think about the model law, which has now tipped over 25 years of existence and well beyond and starting to move beyond that. If we think about where the Singapore Convention might be when it too celebrates more than a quarter of a century of adoption and ratification and utilisation, we might see that it too is starting to shift the needle on the way that mediated agreements are recognised around the world in cross-border situations. So there's quite a bit out there, Annika.
Thank you, Scott. Well, first of all, let me note that I've been doing this for a very, very long time. It's figuring out not so long ago. I've been doing mediations now for over 30 years. So it's a lot of mediations. And one of the things one of the many things that I've learned in the process is that a framework that encourages mediation really, really makes a difference. It used to be accepted wisdom that if the parties were forced to attend the mediation, then the mediation would be doomed to failure because they weren't there voluntarily. That has proved not to be the case. What has actually happened is that in those jurisdictions where mediation is the rule rather than the exception, either because there's a rule in place or because judges insist on it, or it becomes accepted practice, or perhaps because one or more of these conventions have been applied. In those circumstances, the bar makes the adjustment and the clients make the adjustment as well. And it becomes practical, or excuse me, it becomes a matter of practice that mediation is part of the process that they engage in to resolve disputes in addition to the ordinary litigation approach. Now, why would somebody use mediation rather than simply sitting down and doing a sensible thing and negotiating with one another? And the answer to that, for anyone who's ever been a mediator, is that we human beings don't really get along with each other when we disagree. You may have noticed that recently. Conflict resolution is one of those very, very difficult things that's difficult to manage unless you have, as a friend of mine puts it, adult supervision. If there is an adult in the room whose responsibility it is to be true neutral, then that has an ameliorating effect on the level of conflict that people will otherwise experience in the conflict resolution process. And make no mistake about it, all disputes are conflicts. It doesn't matter if it's purely numbers. It doesn't matter if it's purely business. We human beings don't take very well to being told that we're wrong. It doesn't matter what it's about. We just don't take well to it. And it is because of that phenomenon that conflict resolution often requires the intervention of a neutral whose responsibility it is to do a number of things. And I'd like to list them this way. One responsibility is to make sure that there is a person in the room to make sure that no one gets hurt. Job is to make sure that we can speak with each other with candor, but without hurting one another. The expression I've used many times is say what you mean what you say, don't say it means. This issue of conflict resolution is critically important in the process of negotiations. And without a third party neutral there to make sure that happens, it often doesn't happen. And oftentimes things can go off the rails as a result. As anyone who's done mediations, Scott and I talked about this today, knows full well. Another responsibility of the mediator is to be the man who holds up, or the woman who holds up the mirror. That is to say, it's easy to say the other side needs to see things my way. It's difficult for you to look in the mirror and see how things look, having the mirror held in front of you and realize, well, maybe the way I'm looking at things is not quite accurate. Or maybe I should look at things the way the third party would look at them rather than looking at them the way my lawyer describes them. This is a very, very important process in mediation, and mediators' responsibilities are to make sure that they do a good job of holding up that mirror, making sure that they give each party an opportunity to look hard at their own position and ask, have I invested too heavily in my own position so that I no longer see its flaws? Now, there's a very important distinction here, and that is that the mediator not be the person who tells people what the correct outcome is. Mediator must never do that. Mediator's job is to ensure that they hold up that mirror, but not judge positions. And that's because the mediator has the responsibility of building trust with both parties, which is the second and very important feature of the mediation process. The third thing about mediation, and it kind of goes back to the first point that I made earlier, but this is essentially at bottom conflict resolution. And that means that it is the mediator's responsibility to make sure that they remain a true neutral and that they remain somebody that both parties can trust. And if the mediator can do that, then they provide an automatic opportunity for the parties to move on to the next stage, which is the resolution of the problem. I like to think of it this way. Parties come into a mediation sitting on opposite sides of the table. And they put the problem in the center and they say it's your fault. And the responsibility of the mediator is to eventually get the parties so that they're sitting on the same side of the table looking at the problem, saying this is our problem and we need to solve it. And that's how the mediator, I think, moves the parties from simply fighting with one another and starting to actually settle the process. So that's what I have to say about that.
So now looking over to the Austrian perspective, do you have mediation or a framework where mediation is actually considered?
Well, I'm a practitioner, and I have to disappoint you. I'm not able to tell you something about the success story of mediation in Austrian group insolvency proceedings, because there is no story. I could tell you the success story of the Austrian restructuring plan, but this is not our topic. So, well, in general, we have a legal framework for mediation in Austria. We have also education for mediators and we have a list of mediators, but we have no specific framework for insolvency proceedings. Under the European Insolvency Regulation, we have a procedure for the appointment of a group coordinator in cross-border group insolvencies. And this group coordinator is comparable to a mediator. And I guess Franz will tell you more about this group coordinator later. And the Austrian legislator decided that the provisions of the European Insolvency Regulation also applies to purely domestic cases, where all of the involved companies have their center of main interest, their core in Austria. But up to now, we haven't seen any group coordination in Austria. And I dare to say, without an amendment of insolvency law, we won't see one in the future. And why is this the case? Why is group coordination such a flop in Austria? First reason, bureaucracy and time. The provisions, Article 61 to 77 of the Insolvency Regulation deal with the group coordinator. The procedure of appointment is very complicated. It was difficult for me to understand it. And this procedure lasts for at least 1 month. And we know time is of essence in insolvency proceedings. Our proceedings they start immediately. And we don't have preliminary proceedings for 3 months like in Germany. So, and for the appointment of a group coordinator, it is necessary that proceedings are already pending at court. And this is too late. The most important decisions in insolvency proceedings, I dare to say, are taken within the first 1 or 2 months. In debtor in possession proceedings, we have the first creditors assembly within 3 weeks. And the restructuring plan has to be accepted by the creditors within 90 days after opening of proceedings. And if it takes more than 1 month to appoint a group coordinator, this is quite too late. Second reason, the group coordinator has no powers. While he or she has the right to be heard, take part in creditors' meetings, creditors' assemblies, but he or she may give only recommendations. Of course, insolvency practitioners, as we all know, are quite strong personalities. So, while they will follow recommendations, of course, of the judge appointing them, and hopefully will appoint them also in future cases, but not of a third party. And this group coordinator is a third party. He must not be one of the IPs of the involved companies. And he might not take final decisions, so he has no powers. Third reason are costs. We know advisors costs a lot of money in big insolvency cases, and nobody has the need for further costs. And the costs of group coordinations are costs of the concerned insolvency states. And then I got to say, we don't need group coordination in purely domestic cases. Why? Well, we all speak the same language and we know each other. Insolvency practitioners in Austria, they know each other. And if we are willing to cooperate, we can do this without a third party. And if we are not willing to do so, we will not follow the recommendations of somebody who is not involved in the case and coming into the case after 30 days at the earliest. So, to conclude, group coordination as introduced by the Insolvency Directive is not a very effective instrument in Austria due to time, bureaucracy, and lack of powers of the group coordinator. And why is there not really a need for mediation in Austrian insolvency proceedings? Maybe the secret is we have organizations, associations for the protection of creditors. There are 4 of them, 3 general associations and 1 for the interests of employees. And these associations, they are authorized to represent creditors, to take part in creditors' meeting, to inspect the files and court, and they are normally also elected to be members of the creditors' committee. And therefore, we never have any problem to institute a creditors' committee, as we have these associations. And they're part of the proceedings, taking influence, advising creditors, and also helping administrators. And apart from being paid by the creditors, they get a certain percentage of the remuneration of the insolvency practitioner. And therefore, I do think up to now we didn't need any mediation in insolvency proceedings. But Franz might be of different opinion.
Okay, no, I totally agree on this. Yes, it's quite right. The provision and the EU regulation are not very practical, and they have been at the end of the meetings, and they have been introduced and proposed such regulations, such provisions, and yes, and I think nobody was really in favor. Provisions, but yes, the meetings, they want to come to an end, and so to finish it and so on. And so they were putting in force. And we also discussed it in Austria. I chaired the Insolvency Reform Commission in the Federal Ministry of Justice. And yes, and we didn't see any need to make additional provisions. We had long discussions about the competent court for insolvency proceedings of 2022, but we didn't. We also discussed it, coordinator, because I want to add that the coordinator has the task of mediation. There's a new regulation. There is also the settlement of intergroup disputes, intergroup transaction and avoidance action, and also to mediate any dispute arising between two or more insolvency practitioners. And also, there wasn't seen that's not very useful, but there was no need. And yes, and that's, I think, also as the negotiation in the reform group, the insolvency practitioners told us that there is no need because they try to settle the claims and instead of adversary litigation proceedings. And I think that there's one judgment of the Austrian Supreme Court, I think, which is very interesting, in which ruled that the insolvency practitioner is liable for damages if he reaches such an out-of-court settlement. Also, it was clear, totally crystal clear, that he will win the lawsuit. So you see that it's in Austria practice to come to such settlements, and I think it's also necessary to not to have litigation proceedings, which sometimes takes very long, because we have insolvency proceedings which don't last very long. In restructuring proceedings, we have a time limit for 3 months, sometimes a little bit longer, and so it's not possible to have litigation proceedings which take very long. And also, I want to say that also the insolvency practitioners want such settlements, and so I want to add that in the discussions in our reform group, the insolvency practitioners suggested an amendment to the law that a limitation period within he has to bring an avoidance action to the court, which was 1 year, was extended to achieve a settlement. So you can see that I think it's a type of culture in Austria to achieve settlements and so on. And so there's really to have such a and even the coordinator, it's another problem. Susanne is quite right that it's a very complicated procedure which would take too long till such a coordinator is appointed, and therefore, yes, it would be possible in the bankruptcy proceedings, which can take longer, even longer, yes, for years. Yeah, it could be possible. But in Austria, we have 1/3 of our insolvency proceedings and the restructuring plan. So it's very successful, the Austrian insolvency law restructuring. And there, yes, you can't have litigation proceedings which take very long. So you have to finish it in an early stage or avoid it. I think that's in Austria, and I think you have to find out in which cases we can use such a mediation. But because we discussed it and we didn't know such cases, and yes, perhaps we know. And I think, but first of all, it's a question of legislation European level, because that's the framework. In Austria, to add something, it's I don't think it's only for cases which are only in Austria cases, and I think such non-border cases, I think, as Susanne said, the administrators know each other. We have conferences with all of them, I think, Grundlose and so on, and where they meet each other, and so they can settle all the claims. And so, yes, I think it's not really a need. Perhaps there's a need to, yes, to appoint such a mediator, perhaps in some cases, but not in so many cases as in other countries. And I think that's the insolvency culture in Austria, and also the personalities, the administrators who try to reach settlements and so on. Thank you.
I think what we can clearly hear, there's a different perception between civil law and common law jurisdiction. Coming to basically the financial part of it and looking at the business perspective, what's the driving force behind using mediation? Who's driving it, and how do the different parties get to mediator and to mediation? So.
Thanks, Annika. That is a very interesting perspective, I must say, on Austria. So thank you for sharing that. And I didn't appreciate that there was actually such a stark difference. And to be very clear, I'm from Australia, where we have mediation very heavily. It's not Austria, and you might be a very interesting story about that later. This confusion. That's it's a T-shirt for it. Well, it's interesting. I just would like to, though, first make a comment. I will answer that question. But in the contemporary manifestation of mediation or its opportunity, as I say, we think about it, I think, as practitioners and stakeholders in different parts of it, mediation is not really available just to do what it's always been understood to do, which is to resolve a dispute. I think we have a very conventional or traditional understanding of what mediation can do. Sure, it can do that, and I suspect we don't need to spend too much time discussing that aspect of mediation. I think in the insolvency and restructuring context, the untapped opportunity, and this is certainly something that I feel very passionate about, because if this discussion is reconvened in a few years' time, I'm sure there'll be very many examples. But the untapped potential and opportunity is to use the mediation skill set and capability and capacity much earlier in the cycle, whether that's the dispute resolution cycle, whether it's the facilitation of a restructuring plan, whether it's the facilitation and resolution of whether there are disputes or conflict within group enterprise structures, but to think about mediation not just as the final piece after long-running litigation or disputation, but to think more creatively about mediation and to think about the facilitative power. And I listened with great interest to the remarks about mediation not necessarily being of any utility in an Austrian context, but I can think of many situations where parties have, through their representatives, done their best to get so close to finality, whether it's resolving an issue or negotiating a deal or doing something that requires, as was said at the outset, an element of human interaction, but you can't get to that final outcome. Well, there's no question that mediation and that skill set of mediators is probably the thing that will unlock that and move things forward. And so as people interested in insolvency and restructuring more broadly, I think that's the opportunity and the challenge. So to your question though, Annika, what are the drivers and what are the resistors now? Well, the drivers unquestionably are usually related to cost and certainty, and the cost of the litigation system, no matter what country you're in, or access to the court system. And we'll talk perhaps later about emerging economies, the lack of existence of a reliable system will often be the driver to lead parties to thinking about an alternative way to resolve their dispute. That's certainly invariably at the top of the list. The second is certainty. And we all have heard the comment before that you may wish to litigate the dispute, but you may not be happy with the outcome that you'll get from the court or the outcome that you'll get from the judge. Because the judge is there to answer a specific question and to resolve the legal issues that are before them, but they may not be an elegant solution to the real issues and drivers and concerns of the parties. And there's one that I would put as equally significant in that list, and that is increasingly the desire and the drive, especially among those that place great value on their reputation, to resolve disputes or to resolve conflict or to sort out a problem or an issue or to move something forward without the typically very public gaze of the court. I mean, it's impossible to think of any jurisdiction where court proceedings of any degree of interest or excitement are not heavily reported. I mean, famously, and we can only apologise for it, but a former Australian decided to litigate heavily in the US courts recently to rewrite his will before he'd even died. And that man, of course, controls most of the world's media outlets. And you just look at the intense interest around a proceeding that otherwise was, despite their best efforts to keep it private, was not able to be kept private in any real sense. And so mediation is clearly a device and a facility that's cloaked in privacy and secrecy. So if reputation, which I think is invariably a critical driver for most businesses, let alone individuals, then you'll get perhaps a happier outcome through that process than a court. So there's some of the drivers I might let.
Well, I think you've done a really good job of canvassing the territory. One of the things that Scott and I were talking about a little bit earlier, as we were preparing for this, was the concept of a chief facilitation officer. And I'm thinking here of a global enterprise with corporate interests in many different countries, perhaps, in which the boards of the various related entities are not necessarily getting along with one another. You may have one particular part of the enterprise that's sucking up all of the resources, and another part of the enterprise that is providing all the resources and not getting very much of a return. For example, you may have boards that end up becoming adverse with one another and then simply become so adverse that they can't talk with each other anymore. And Scott said, floated this notion of a chief facilitation officer who could, in the context of restructuring the enterprise's total efforts, could not facilitate a global settlement, but facilitate a series of settlements that may come up during the course of the restructuring process, which struck me as an interesting use of a mediator who is on call and available to resolve discrete disputes that arise, perhaps between boards, between officers, or between particular large creditor groups, between different companies. That might be especially valuable in the context of enterprises that are proceeding under more than one insolvency regime, which is what enterprise group insolvencies contemplate. Possibility that you will have insolvency proceedings pending under more than one insolvency regime, and therefore you can't entirely predict the outcome because you don't know which insolvency regime will, at the end of the day, if any of them, ultimately predict the outcome of the case, which is a perfect recipe for mediated resolution. And it struck me that was an interesting approach to the idea of introducing mediation in the resolution process as more than simply solve this dispute, but rather using that officer as someone who could solve multiple, assist to accommodate the players in resolving multiple disputes, especially in contexts where you had to rely on the more than one insolvency regime. Different rules might apply to how things could split up depending on which regime prevails. So it struck me that was a very, very interesting and intriguing idea. There is, as noted in these comments, the issue of familiarity with multiple insolvency regimes and ultimately different cultural regimes. I did a mediation some years back that involved a Greek shipping company which filed for bankruptcy in the United States to the great surprise of its German lenders. And one of the things that needed to be dealt with in the process was dealing with the shock of the German lenders, what might actually happen to them in this U.S. insolvency proceeding if things proceeded. Shock is hardly describes their reactions. So, you know, understanding that their very, very different take and their very, very different view of things was critical to helping the parties ultimately reach a resolution that was satisfactory to everyone. And we reached such a satisfaction. Other proceedings that you know, all of us have, well, I say all of us, I know Scott has been involved in. Can't speak for my colleagues from Austria, but involved Chinese proceedings and the various different expectations that not only arose from whether Chinese law and Chinese courts would ultimately have control of the resolution, but also the culture of the business culture that attached to how the Chinese approach the whole transaction and having an appreciation of how that might play out in the course of mediation. So these are things that are, I think, interesting challenges for mediations, especially if mediation becomes what I hope to be a useful tool in a private insolvency regime.
I would just have a follow-up question, and then also goes to all of you. We always talk about mediators. So what is a mediator? Is it just a professional insolvency administrator with mediation education in the different countries? What do you see?
So in Australia, but I guess speaking more broadly than that across Asia Pacific, but this will be my perspective globally, it's usually somebody from the spectrum from sitting judge. In some instances, we of course have sitting judges acting as mediators, not in their own cases, you'll be pleased to know. We have retired judges, and of course there's an outstanding example right here. He said that he was retired. I don't think he's retired based on the number of mediations I hear that he's undertaking. And then, of course, professionally trained mediators and practitioner mediators. There might be other varieties, but that's typically what we see turning up in many instances. And I do think that across insolvency and restructuring globally now, as a consequence of many of the initiatives and the endeavours you've heard spoken of tonight, there is a, not quite a panel, but there's a recognised group of globally equipped mediators who are expert in helping resolve significant insolvencies and restructurings, especially cross-border ones. And I think the evolution of that probably began earlier than the collapse of Lehman Brothers, but I'm sure that the collapse of Lehman Brothers created a driver. We, of course, know that the model law itself was inspired as a consequence of the collapse of the Maxwell group of companies in the mid-1990s, early 1990s. And then I would suggest that the supercharging of focus on mediation absolutely would have to have been linked around the time of Lehman Brothers, because we saw then wickedly complex cases that needed resolution with apparatus beyond just what the court was able to offer. And of course, as we know, some parties were not prepared to enter jurisdictions of certain courts, but still needed to resolve their disputes. And I think that has been overall an incredibly positive development.
So let me just footnote that with a couple of different thoughts. One is it's critically important that mediators in this space be persons who are knowledgeable of the issues that arise in cross-border